Dominic said, I want to reiterate, which is that the koi room has the vendors in them. Please visit them because they can give you interesting and fruitful ideas for improving language access. And we also have some samples of what some of the state agencies have done in terms of translations and translated materials. In terms of the evaluations, we really do need your feedback because we really do anticipate that this is only the first conference. In order to have better and more conferences, we need your feedback on what else needs to be done and how we should be going about doing it. So please fill out and turn in the Friday evaluation today. There'll be boxes out front. And then the Saturday one is on Saturday, obviously. And then if you're leaving early, fill in the top half and fill it in. But we really do want you to fill in the evaluation. It is important to us. Lastly, at the end of the day, don't leave. There is a reception downstairs and also another opportunity to go visit the vendors. But there is a reception with poo-poos and an opportunity to meet some of the speakers and some of your friends and some of your colleagues in this area. So hopefully you will be able to stay and enjoy the reception as well. Some sessions only have 5 minutes between them to allow you to walk to the other room. So please take that into consideration when you have to do other things. I won't have to detail what those are. It's so again, let me start again in a different way. Annyeong haseyo. It is my pleasure and privilege to introduce Grace Chung Becker, Acting Assistant Attorney General, to you. However, you have, as you have for all the speakers, biographies in the program. So I won't go through that again. I think you can be already suitably impressed by what has been said about Ms. Becker simply in the printed word. I want to give you a more personal, perhaps, viewpoint of what she's like. She's smiling over there, wondering what I'm going to say. Okay. She is the daughter of immigrant parents, born in New York City, one of my favorite places, but that means she knows one end of the country, and she knows a very busy part of the country, and hopefully she will get an opportunity later on, perhaps, to know our side of the country. She was born in the year of the rooster. Now, you can stop figuring out exactly what that means. She is the youngest of 4 children, which probably means, in some of the PR stuff that she had, it said that her parents instilled in her diligence and passion for education. I suspect it might have been the fact that she's in the year of the rooster and she's the youngest of 4 children. That might have had something to do with it as well. The other thing that I wanted to mention, because this is Hawaii after all, is she is very fond of sundubu with sashimi over rice with gochujang sauce. So now you know one of her favorite dishes. You can share with her yours. Okay, so with no further ado, let me introduce you to Grace Chung Becker, as Acting Assistant Attorney General.
Thank you for that very personal and warm welcome. It is an honor and a pleasure to be here today. Aloha, 안녕하십니까? I cannot think of a better place to hold a language access conference than right here in Hawaii. And I'm not saying that because it gave me a chance to come to Hawaii for the first time, but truly Hawaii has been a historic place for Asian immigration. Over 100 years ago, on January 13th, 1903, the first Koreans to immigrate to the United States arrived right here in Honolulu on the SS Gaelic. As a result, it should come as no surprise that census data indicates that Asians make up 58% of the population in Hawaii, the highest proportion of Asians than any other state in the country. And just for comparison purposes, the national population of Asians in the United States is 5%. So to have 58% is really tremendous. Such a large Asian American population makes this a particularly fitting place to discuss an issue that is of great significance to the Asian and Pacific American community, as well as other immigration communities throughout the country. As someone who comes from a family of immigrants, language access is an issue that has personal significance to me. My parents and all three of my siblings immigrated to New York from South Korea. English was my parents' third language, after Korean and after Japanese. My oldest brother and his wife have limited proficiency in English, and my other two siblings were beneficiaries of classes teaching English as a second language in the New York City public schools. And as a person who spent months living in South Korea, notwithstanding my limited Korean proficiency, I can personally appreciate the challenges and frustration that individuals face when you have a limited ability to communicate with others in a land far away from the home that you grew up in. In the time that I have this morning, I will briefly discuss the Justice Department's work across the country to help individuals with limited English. As some of you may know, the Civil Rights Division was created in 1957 in the legislative wake of the Supreme Court's landmark decision in Brown versus Board of Education. That decision required schools to integrate students of all races. Many of us remember the Brown decision as instrumental in opening up opportunities for African Americans to go to integrated schools with whites. But let us not forget that the Brown decision also opened up educational doors for Asian Americans, as well as by overturning a 1927 Supreme Court decision called Ganglum versus Rice. In that case, the court ruled that a Chinese girl was too yellow to go to a public school attended by white children. Citing cases like Plessy versus Ferguson, the court stated, quote, "We cannot think that the question is any different or that any different result can be reached where the issue is as between white pupils and pupils of the yellow races," unquote. And although 50 years have passed since the Civil Rights Division was created, we still have much work to do to ensure that those with limited English proficiency, or LEP as we call it in Washington, are provided the services that they are entitled to in education, federally funded programs and activities, and in protecting their right to vote. In fact, one of the most significant LEP statutes that we enforced was enacted over 40 years ago, the 1964 Civil Rights Act. Title VI of that act requires that programs and activities that receive federal funds cannot discriminate on the basis of race, color, or national origin. In 1974, the Supreme Court, in the case of Lau versus Nichols, interpreted Title VI and its regulations to require a San Francisco school district that had a significant number of non-English speaking students of Chinese origin to take steps to provide those students with a meaningful opportunity to participate in federally funded educational programs. The Civil Rights Division intervened in the Lau case and continues to ensure that San Francisco school districts meet its obligations with respect to English language learners. In that same year, Congress modeled a provision of the Equal Educational Opportunities Act of 1974 on the Lau decision to ensure that English language learners are provided a fair opportunity to succeed. Today, the Educational Opportunities section of the Civil Rights Division is working to make sure that our nation's school children are afforded equal opportunities in the classroom. Over the last 3 years, we've opened over 20 investigations to ensure that public schools are meeting their educational opportunities for students with limited English. We brought cases or reached settlement agreements in states ranging from California to Illinois to Maine. For example, in our Chicago school desegregation case, we negotiated comprehensive relief on behalf of English language learners, what we call ELL. There are approximately 600 schools in that school district, and the Chicago Public Schools enroll approximately 52,000 ELL students from more than 100 language backgrounds. In reviewing the school district, we found that after a certain period of time, the district was exiting students from ELL programming, even if the students had not reached English proficiency. Additionally, we found that many special education students who also require ELL services were not receiving them. When reviewing services at some schools, we found that ELL classes were given in hallways and materials were lacking. We are continuing to enforce federal laws to ensure that the Chicago Public Schools meet its obligations to help ELL students. And just yesterday, the court granted a motion we filed based on these recent problems. The court required that Chicago principals submit affidavits concerning the services being provided at their school and increase the government's access during ELL monitoring visits. In another case, we sought relief for ELL students in Lewiston, Maine, a town of about 35,000 in which recent years has seen a large influx of Somali refugees. By and large, these refugees shared the common values of Lewiston residents and wanted to raise their children in a safe, quiet community. The issue, of course, was that many of these refugees spoke little, if any, English. Through negotiations with the Lewiston School Department, the school department entered into an agreement to ensure that these ELL students would receive equal educational opportunities. To accomplish this, the school district agreed to create standardized curricula for ELL students, adequately train its teachers, and ensure that ELLs were able to participate fully in the offerings of the school district. The goal in all of these programs is to bring students to a point where they can participate in regular English-only classes and receive equal educational opportunities. But the Civil Rights Division efforts go beyond the public schools. In addition to the Educational Opportunities section, we have a coordination and review section that coordinates enforcement of Title VI of the Civil Rights Act to ensure equal access to federally funded programs. And a major part of our work involves ensuring equal access to those who are limited English proficient. Nearly 8 years ago, Presidential Executive Order 13166 was signed. This order required every federal agency that provided financial assistance to state, local, nonprofit, and other entities, and there are nearly 30 of these federal agencies, to identify any need for services to those with limited English proficiency, and to provide those services so LEP persons can have meaningful access to them. Additionally, these federal agencies are required to issue guidance to their recipients to ensure a better understanding of their legal obligations to take reasonable steps to provide meaningful access to LEP persons. Thus, the Justice Department issued guidance to law enforcement, juvenile justice, district attorneys, and a variety of other recipients of federal funds. Our sister agencies have issued guidance to housing, social services, employment, transportation, parks and recreation, and a myriad of other types of state and local agencies to ensure that they understood their obligation to take reasonable steps to provide meaningful access to LEP persons they encounter or serve. The Coordination and Review section has had a leading role in the government-wide implementation of Executive Order 13166. We have undertaken a language access initiative and created a federal interagency working group. We have developed a new website, www.lep.gov, and I encourage all of you to visit the website. It's a clearinghouse for legal, demographic, planning, and other tools to assist in the provision of language access. The working group has also developed brochures in many languages designed to help LEP persons understand their rights, and one for federal agencies and recipients of federal funds. The Coordination and Review section provides training and technical assistance, and with the help of other agencies has created a training video, which is available in English, Spanish, Vietnamese, and has subtitles in Chinese and in Korean. In March of last year, the Coordination and Review section took the lead in coordinating a major two-day federal interagency conference on LEP. Hawaii was represented there, and the conference provided an opportunity for over 300 representatives from federal, state, and local agencies, community organizations, and interpreters and translators from around the country to share their ideas about LEP programs and practices. It's my understanding and my hope that it's proven helpful to Hawaii in its efforts to improve language access. We're hard at work at preparing for the next interagency conference this year. We have a date. It's going to be on September 3rd at the National Institute of Health in Bethesda, Maryland, which is right outside of Washington, D.C. The Coordination and Review section also ensures that law enforcement agencies, corrections, courts, and other entities that receive DOJ funds comply with the language access law. Just last week, for instance, the department entered into an agreement with the town of Mattawa, Washington. Its police department had allegedly failed to provide sufficient police protection to Hispanic victims of domestic violence due to a failure to take reasonable steps to provide meaningful access to LEP Spanish speakers. The town has now agreed to implement a strong language access policy, which includes the hiring of interpreters and translation of vital documents, and establishes an outreach program to ensure that the LEP community is included in town services and programs. Town officials have worked diligently to hire interpreters and bilingual staff and began implementing measures to ensure that LEP persons had access to town services even before an agreement was reached. This is the first agreement of its kind in the state of Washington, and I commend the town for its leadership in this area. In another enforcement action, the Coordination and Review section worked with the state of Maine to ensure equal language access in its court system. We worked with the state courts of Maine to develop an order providing interpreters for all LEP persons in both civil and criminal cases, and to improve language access to clerks' offices and other points of entry. In another case, the chief of police of the town of Lake Worth, Florida, signed a settlement agreement to address the needs of a growing LEP population. He also signed a comprehensive language access plan for law enforcement, which covers everything from his 911 call center to training for bilingual officers. Finally, you should know that Executive Order 13166 does not just impose requirements on state and local funding recipients. It also requires that the federal government meet the same access standards that it sets for its funding recipients. Approximately 85 federal agencies, including the Department of Justice, Social Security Administration, the Center for Medicaid and Medicare Services, federal agencies charged with immigration enforcement and services in emergency preparedness, and others need to coordinate and implement strategies to reach out and respond to the LEP populations we serve. Each federal agency must create and implement an LEP plan, and our federal interagency group on LEP has surveyed each federal agency and is developing recommendations for improvement and highlighting promising practices. And of course, since we are in an election year, I thought I would tell you about our work to ensure that all voters, including those with limited English proficiency, have equal access to the ballot box. The Civil Rights Division is charged with enforcing the Voting Rights Act of 1965, the landmark legislation that is known for protecting the right to vote for African Americans, particularly in the South. But many people do not know that the Voting Rights Act also protects the rights of language minorities by requiring certain jurisdictions to provide election materials and assistance at the polls in languages other than English. Currently, the Civil Rights Division is in the midst of the most vigorous minority language enforcement program in its history. In this administration, the Civil Rights Division has filed more than 2/3 of all of the cases ever filed under the minority language provision of the Voting Rights Act in its 43